What the flip is up with blocking a whistleblower from the intelligence committees? That's next on What the Flip. Well, I'm going to leave it up to you to find and read the whistleblower bill that passed. And yes, both Democrats and Republicans passed this bill. Today, September 20th, 2019, a whistleblower's information is being withheld from Congress challenging this law. Now, it's obvious the whistleblower law was designed and unanimously voted on into law to help deal with things like the Snowden fiasco. It's designed to give members in the intelligence community an opportunity to speak out when they feel something might not be right or there's a violation of the law or policy or ethics. However, no one, including Republicans, ever imagined we would have a president who would conduct themselves in a way that an intelligence professional might challenge the president's actions under the Whistleblower Act. In fact, many people were surprised when Donald Trump was elected, including Republicans, and now with this whistleblower challenge of Donald Trump's actions, even Republicans are surprised they now have to find a way to circumvent the law that a majority of them voted on to protect Donald Trump. What the flip is wrong with this picture? Well, first, we now have proven that a whistleblower is no longer protected. That, in and of itself, is absolutely disgusting. It appears they are trying to figure a way to discredit the whistleblower and prove it was not a legitimate whistleblower incident, even though an inspector general reviewed it and found it credible and urgent enough to report. So you might as well get used to future Snowdens, and you can only blame the president, his staff, and the GOP for this eventuality. Leaks will abound, and that is dangerous for our country and intelligence agents. All right, let's briefly look into the law governing this issue. Now, I'm not an attorney, and this is not legal advice, but I give credit to everyone out there that you can read and understand what is written. Now, you can bet attorneys will bend the interpretation to fit their interest. However, you can at least read the segments of the law for yourself and draw your own conclusions, and be informed as you watch legal presentations presented in the media. First, the whistleblower followed the law and reported it to the Intelligence Inspector General. The Inspector General followed the law and reported it to the Acting Director of National Intelligence. Both the whistleblower and Inspector General are given the benefit of the doubt that they are career professionals dedicated to non-political behavior in their jobs. First, the law is about the Inspector General's responsibility within the intelligence community, which is cited as 50 U.S. Code 3033, Inspector General of the Intelligence Community. Starting in subparagraph K of this law is where the whistleblower element is relevant. Subparagraph K is entitled Reports. We're not going to cover all of subparagraph K's areas, but simply those that relate directly to the issues. Now, I'm providing a link to this act so you can read it yourself. We don't have time to cover all the aspects of the total act. Generally speaking, in the first few paragraphs, the act describes the reporting process of the Inspector General to the Director of National Security, but in this case, the Acting Director. It says not later than 30 days after the date of receipt of a report under subparagraph A, the Director shall transmit the report to the Congressional Intelligence Committee together with any comments the director considers appropriate. The director shall transmit to the committees of the Senate and of the House of Representatives with jurisdiction over a department of the United States government any portion of the report involving a component of such department simultaneously with submission of the report to the Congressional Intelligence Committees. What's happening in this whistleblower incident is an exception to this ongoing reporting process, and that is what we will cover next and what all the fuss is about. So this is section 5 under subparagraph K of this act, entitled Reports, just to keep you on track. I'm going to read these paragraphs directly from the laws presented by Cornell University Law Legal Information Institute of Law website. All right, let's start with subparagraph 5, which gets into the whistleblower stuff, and this is subparagraph A of that. An employee of an element of the intelligence community, an employee assigned or detailed to an element of the intelligence community, or an employee of a contractor to the intelligence community who intends to report to Congress a complaint or information with respect to an urgent concern may report such complaint or information to the Inspector General. This whistleblower for this event followed this law. Now, paragraph B of subparagraph 5, not later than the end of the 14th calendar day period beginning on the date of receipt from an employee of a complaint or information under subparagraph A, the Inspector General shall determine whether the complaint or information appears credible. Upon making such a determination, the Inspector General shall transmit to the Director a notice of that determination, together with the complaint or information. The Inspector found this whistleblower's information to be credible and urgent, and reported the whistleblower's complaint to the Acting Director of National Intelligence, so they followed the law also. Okay, subparagraph C in this chain, upon receipt of a transmittal from the Inspector General under subparagraph B, which we just talked about above, the Director shall within 7 calendar days of such receipt forward such transmittal to the Congressional Intelligence Committees together with any comments the Director considers appropriate. This is where it really all falls apart. The acting director did not report the Inspector General's report to the intelligence committees. Instead, he took it to the Department of Justice, who then stopped reporting to the Intelligence Committee. The vague grounds that the Department of Justice is using not to share the report is either not known or questionable, to say the least. However, and the next subparagraph is a hit. Subparagraph D. If the Inspector General does not find credible under some subparagraph B a complaint or information submitted under subparagraph A, in other words, either the employer and the Inspector General finds the employee wasn't correct or whatever, or does not transmit the complaint or information to the director for whatever reason, it's either inaccurate or not done properly or whatever, the employee, subject to a clause we're going to cover in a little bit, may submit the complaint or information to Congress by contacting either or both of the Congressional Intelligence Committees directly. So, if the Inspector General does not feel what the employee says is credible and urgent and does not report it to the director, the employee can contact the Congressional Committees directly. There is no statement saying what would happen if the report is delivered to the director but the director fails to deliver the report to the intelligence committees. But the inference would be that the employee has the same right to contact the congressional committees. That really only makes sense. It gets even muddier here. The way this law is written does not clarify if the acting director fails to do their job as stipulated relative to the employee's rights to contact the Congressional Intelligence Committee. As I mentioned earlier, it seems logical they would have that same right in that circumstance. But an employee may contact the Congressional Intelligence Committees directly, as described in Clause 1 just above, which is part of this reporting to the Intelligence Committee section, only if the employee first, before making such a contact, furnishes to the director through the Inspector General a statement of the employee's complaint or information and notice of the employee's intent to contact the Congressional Intelligence Committees directly. Okay, and secondly, obtains and follows from the director through the Inspector General direction on how to contact the Congressional Intelligence Committees in accordance with appropriate security practices. So the employee must communicate with the Inspector General that they want to communicate directly with the congressional committees. But what they deliver must be discussed with the director about what is protected under national security laws. Now, all this assumes an unbiased and ethical director or acting director of national intelligence. I should note for you here that this incident evolved over time, starting in July and August of 2019, and not long after this incident started, the Director of National Intelligence, Dan Coates, and his assistant resigned before all this came to light. Now, relative to who on the Congressional Intelligence Committee can receive these complaints from the employee, this stipulates a member or employee of one of the Congressional Intelligence Committee who receives a complaint or information under this subparagraph does so in that member or employee's official capacity as a member or employee of such committee. All right, so here we are today. The acting director stepped outside of these guidelines because the issue involves the President of the United States. There are efforts from the Department of Justice and the White House to restrict the Intelligence Committee's access to the Inspector General's report. Inspector General, in a closed-door committee meeting, stands by his interpretation of the report as credible and urgent, but has been muffled under this rule saying what can and cannot be shared with the committees. Now, it appears the Trump administration and the Department of Justice reviewed the data and has overruled the Inspector General's finding that the report is credible and urgent, has even inferred the incident does not fall under the Whistleblower Act and is considering taking action against the whistleblower. That's reprehensible. However, as I read this, the employee could go directly to a member of the committee with their complaint as long as they let the Inspector General and Acting Director of Intelligence know they are and receive direction on how to protect national security issues. Of course, basically what they would be told is that the White House is telling everyone who work for them, and that is, you have to abide by some sort of executive privilege which no one seems to be able to clearly define. So we go to court again, a waste of time. If the president has nothing to hide, like he says in every news report that he's interviewed in, then let the report be seen by the Intelligence Committee. They've seen far more classified incidents than this one, unless Trump has openly committed a crime, which, unless they release the information to the Intelligence Committee, sure sounds viable. We will see how the courts handle it in the end. This is just one more thing to add to your list of many other issues to help you decide to vote corruption out of the White House and vote Donald Trump out of the White House, along with everyone else who supports him. I'm Vic Vogel, your host for What the Flip. Stay tuned.